Welcome to the HR Toolbox, the podcast where we help you build your toolbox of resources, best practices, and strategies shaping the world of HR and business today. Whether you're an HR professional, small business owner, office manager, or someone wanting to learn more about today's work environment, we're here to help. Send us an email at hrtoolboxpod@gmail.com to suggest a topic or resource tool you want to learn more about. The HR Toolbox is here to help businesses stay compliant and competitive. I am your host, Amy Alden. I am committed to your business success one tool at a time. Let's dive in and see what we find in our HR Toolbox this week. Coming up in the calendar, February 9th through the 15th is Random Acts of Kindness Week. And February 17th is National Random Acts of Kindness Day. This day was started in 1995 in Denver, Colorado by a nonprofit organization that wanted to make the world a better place. Random acts can be small gestures that can spread organically. There are many ways that you can bring kindness into your workplace. You can compliment others, be an active listener, help coworkers with projects, leave a thank you note for those who don't usually get recognized, like janitorial and building maintenance staff. And don't forget to practice self-kindness. You need to be kind to yourself. Coming up on February 13th is Employee Legal Awareness Day. This day was started to emphasize the importance of legal education for employees and small businesses. When we have updated handbooks and we openly communicate with our employees on policies and regulations, we reduce our risk of legal issues. Coming up on February 14th is National Organ Donor Day. So most states have leave laws that provide time off for organ donation. Some states, they'll offer a tax credit to an employer, which helps offset the paid leave that the employees take when they donate an organ. So that would be like Arkansas or Louisiana have those tax credits available. Others specify the amount of unpaid leave an employee can take, like in the state of New York. Most states have paid leave. They'll have paid leaves for state employees, and then some states also have additional conditioned paid leave for private employers like South Carolina and Oregon, where they have organ donor paid leave if the business has 20 or more employees. Even if you're in a state that does not have a specific leave law for organ donors, for employers that have more than 50 employees, organ donation is covered under FMLA. Our definition of the week: EEOC, U.S. Equal Employment Opportunity Commission. The EEOC is the federal agency that enforces federal laws that prohibit employment discrimination based on race, color, religion, sex, including pregnancy, sexual orientation, or gender identity, national origin, disability, age, 40 years and older, and genetic information, including family medical history. The EEOC is a bipartisan commission that's led by 5 commissioners who are appointed by the president and confirmed by the Senate. The EEOC has headquarters in Washington, D.C., and they have 53 field offices throughout the United States. Today, we're going to take a deep dive on anti-discrimination regulations and the new executive order dealing with discrimination in the workplace. We're going to work through the current law, including the background of the Civil Rights Act of 1964 and Title VII, and how that affects small businesses. I do want to note that we recorded this episode on January 31st, 2025. This is a developing change in law, and we are providing information based on our current understanding. While we strive for accuracy, laws and interpretations change, so we encourage you to stay informed through reliable sources. And in this episode, we're going to be explaining the law as it is, in a factual and neutral manner. Our goal is to provide a clear understanding of the legal framework without any political or partisan interpretation. So this is purely an informational discussion, not an endorsement or critique of any policy or position. Additionally, I am not a lawyer, and our discussion is for general informational purposes only. So let's take a look at anti-discrimination in the workplace. We're going to start with the history. When we think of our anti-discrimination clauses that are in our handbooks and our policies, what part of our day-to-day practices should they be applied to? They need to be applied to all aspects of business practices and employment. They need to be applied when we're hiring, when we're determining pay, when we're working through promotions, benefits, determining working conditions, separations, and accommodations. Anti-discrimination clauses are part of all business practices. Now, these policies and regulations tie back to several civil rights laws that were signed into law going back to 1941. But the most significant and recognized is the Civil Rights Act of 1964, and within it, Title VII. Title VII created the EEOC, or the U.S. Equal Employment Opportunity Commission. As with any extensive legislation, there are adjustments along the way. As we implement the regulations and we find that a more thorough definition or a clarification or a new interpretation is needed to handle situations that might not have been known or originally covered by a particular law. There are several acts, amendments, and legal rulings that cover the extensive framework to prevent workplace discrimination. Going through the most significant of those being the ADEA, or Age Discrimination and Employment Act of 1967. This was passed by Congress and signed into law by President Lyndon Johnson. It protects individuals over the age of 40 from discrimination in the workplace. The Equal Employment Opportunity Act of 1972, passed by Congress and signed into law by President Richard Nixon. The EEOA expanded the number of employers that were covered by Title VII, including making state and local governments no longer exempt. This provided discrimination protection to over 10 million employees. It also reduced the number of employees needed for an employer to be covered from 25 down to 15 employees. It gave the EEOC the power to prevent unlawful employment practices and the power to enforce Title VII through the federal courts. This act also stated that the federal government was also subject to Title VII, meaning that federal executive agencies and other branches were to make all personnel actions free from discrimination based on race, color, sex, religion, or national origin. The next one we have is the Pregnancy Discrimination Act of 1978. This was a congressional amendment and was signed by President Jimmy Carter. This clarified that discrimination based on pregnancy is unlawful. The next one we have is Immigration Reform and Control Act of 1986, passed by Congress and signed into law by President Ronald Reagan. This prohibited employers with 4 to 14 employees from discriminating on the basis of national origin, and it also prohibited citizenship discrimination. The ADA, or Americans with Disabilities Act of 1990, was signed into law by President George Bush. Title I of the Act prohibits discrimination against people with disabilities in employment situations. GINA, the Genetic Information Non-Discrimination Act of 2008, was passed by Congress and signed into law by President George W. Bush. The act protects Americans against discrimination based on their genetic information with respect to health insurance and employment. The ADAAA, otherwise known as ADA Amendments Act of 2008, was passed by Congress and signed into law by President George W. Bush. The ADAAA, I always think I'm going to forget an A, but the ADAAA broadened the definition of what it was a disability. It clarified that if an impairment limits one major life activity, is considered a disability, even if it doesn't limit other major life activities. The Lilly Ledbetter Fair Pay Act of 2009 was passed by Congress and signed into law by President Barack Obama. This law adopted the EEOC's longstanding position that each paycheck that contains discriminatory compensation is a separate violation regardless of when the discrimination began. Executive Order 13672 was signed in 2014 by President Barack Obama, and it prohibited federal departments and agencies, contractors, and subcontractors from discriminating against individuals based on their sexual orientation or gender identity. In 2020, Bostock versus Clayton County Supreme Court ruling was a landmark ruling that interpreted sex under Title VII to include sexual orientation and gender identity, protecting LGBTQ+ employees from workplace discrimination. The Pregnant Workers Fairness Act of 2022, passed by Congress and signed into law by President Joe Biden, requires covered employees to provide reasonable accommodations to a worker's known limitations that are related to pregnancy, childbirth, or related medical conditions. From all of this, American employers, it is illegal to discriminate against someone, either an applicant or an employee, because of that person's race, color, religion, sex, including gender identity, sexual orientation, and pregnancy, national origin, age, 40 or older, disability, or genetic information. It is also illegal to retaliate against the person because he or she complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. These laws forbid discrimination in every aspect of employment. To review the current executive order, on January 21st, 2025, President Donald Trump signed an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The policy specifically orders all executive departments and agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements for DEI. It also orders all agencies to enforce the civil rights laws and to combat illegal private sector DEI preferences, mandates, policies, programs, and activities. To do this, the current executive order revoked the following items. An executive order from 1994 that stated that federal agencies must ensure that their programs, policies, and activities do not discriminate against people, particularly in the area of environmental justice in minority populations and low-income populations. That was revoked. An executive order from 2011 that established a government-wide initiative to promote diversity and inclusion in the federal workplace. That was revoked. An executive order 13672 from 2014 that prohibited discrimination in the federal workforce and in hiring by federal contractors based on sexual orientation, gender identity, and transgender status. This was revoked. A presidential memorandum from 2016 that provided guidance on the implementation of policies to promote diversity and inclusion in the national security workforce. That was revoked. An executive order 11246 from 1965 that prohibits federal contractors and federally assisted construction contractors and subcontractors from discriminating in employment decisions on the basis of race, color, religion, sex, sexual orientation, gender identity, or national origin, to ensure that equal opportunity is provided in all aspects of their employment, also to not take any retaliatory actions against applicants and employees from discussing their pay. This was revoked. But to note, even though Executive Order 11246, which we just discussed, was revoked, federal contractors have 90 days from the date of this order where they can continue to follow this executive order from 1965. Specifically, affirmative action practices can continue for 90 days from January 21st. Additionally, the current executive order says that the Office of Federal Contract Compliance Programs needs to stop promoting diversity. They need to stop affirmative action practices in federal contractors and subcontractors, and they need to stop balancing workforce based on race, color, sex, sexual preference, religion, or national origin for all federal contractors. It also addresses that any new contracts that come forth will contain wording that they do not have any DEI programs or practices. So this includes any wording or programs that include the words diversity, equity, equitable decision-making, equitable deployment of financial and technical assistance, advancing equity, or similar. Another section of the current executive order talks about encouraging the private sector to end DEI programs, and for the current administration to make recommendations on how to end DEI programs in the private sector. The government is told that they need to develop ways to investigate publicly traded corporations, large nonprofit corporations or associations, large foundations, state and local bar and medical associations, and institutions of higher learning with large endowments to make sure that they do not have DEI programs or principles. And that within 120 days, the Attorney General needs to provide information that would make federal lawsuits against DEI possible, as well as information to help create regulations against DEI in the public sector. Now, that was a lot of info. I know. We are going to dig a bit deeper on two specific pieces that were revoked, but I will make sure to circle back around, and we're going to explain what all of this means to your company. The current executive order revokes Executive Order 11246 and Executive Order 13672. Executive Order 11246 required government contractors to include in their contract and in their business practices that they would not discriminate against any employee or applicant because of race, color, religion, sex, sexual orientation, gender identity, or national origin, and that they would use affirmative action in hiring and employment practices. That they would post notices on equal employment in the workplace and in their job postings. That they would prohibit government contractors from retaliating against an employee or applicant for asking about or discussing compensation. That would require filing of compliance reports. Specifically, they were talking about the EEO-1 annual reporting. And that the government contractors could lose their contracts and possibly future contracts if they did not comply with anti-discrimination and affirmative action requirements. Now, we do need to note that the revocation of this particular executive order did not affect equal employment opportunities and affirmative action for veterans or blind individuals in having hiring priority for operating vending facilities. Those two distinctions should still be considered in effect, that they're protected and required by all federal contractors. Now, you might be saying, did she just say blind individuals operating vending facilities are protected? I did. The executive order specifically notes that it does not apply to persons protected by the Randolph-Shepard Act. Now, I have seen some outlets interpret this as all blind persons. Some other places have interpreted it that it's including all people with disabilities. But if we're interpreting this as written, the Randolph-Shepard Act sets hiring preferences for blind persons to operate vending facilities on federal property. That is what is specifically called out. Now, we're going to keep an eye out because this might get officially clarified further. We might see some more information come out on this. We're not sure. But as of right now, even though the older executive order has been revoked, it does not affect veterans or blind individuals in having hiring priority. The other thing that was revoked was Executive Order 13672. This prohibited federal departments and agencies, contractors and subcontractors from discriminating against individuals based on their sexual orientation or gender identity. With this, according to President Donald Trump's current executive order, it still protects individual Americans from discrimination based on race, color, religion, sex, veteran status, or national origin. So what does this mean for employers? We will start that this executive order focuses on federal government agencies and federal contractors. Federal government contractors are companies that provide goods and services to a government agency in exchange for payment. These could be nonprofits like religious, charitable, or educational organizations. They could be privately owned and operated employers. They could be publicly traded companies or public employers like cities, states, and other government agencies. So if you are a business that has a contract or subcontract with the federal government, you will need to make changes to comply with this executive order. Again, according to the current executive order, it still protects individual Americans from discrimination based on race, color, religion, sex, veteran status, or national origin. It also protects certain individuals who are blind. I would expect that additional information is going to be released to help advise on any specific verbiage that is required. The deadline for this at this moment is 90 days, so we're looking at April 20th, 2025. Until then, affirmative action would still technically be in place in workplace practices for federal contractors. The immediate changes that are required by the executive order would include removing any DEI program, practices, or wording from your company's information, and prepare for updating your contracts with the federal government with the removal of all DEI language. Now, do all employers need to do this? The answer is no. The executive order removes DEI items from federal agencies and companies that have a contract with the federal government. Now, we did note that there is a section that talks about the private sector. Yes, the current executive order discusses the private sector. This was in reference to encouraging private sector businesses to end their own DEI programs. For small businesses that do not have federal government contracts, there is no legal obligation at this time to end DEI initiatives. The current executive order wants work to start on ways to investigate larger entities to remove DEI programs and principles. It is also trying to figure out how to create regulations that would remove DEI from the private sector. There is no regulation in place at this time that does that. The timeline for this is 120 days from the executive order. This would be May 21st, 2025. We are going to see more information on this in the upcoming months. Again, this is only for DEI programs and wording. This does not change the anti-discrimination laws that are still in place. All agencies, businesses, employers still need to follow the protections under Title VII, the ADA, the ADEA, and all the other acts and amendments that we went over at the beginning of this episode. Those are still in play. There is no change to the fundamental protections that those acts provide, all of which continue to prohibit employment discrimination in all aspects of business practices and employment. So, from hiring, promotions, benefits, working conditions, separations, all of those protections are still in place. So moving forward, what should employer responsibilities be? Well, Title VII still applies to employers with 15 or more employees. This includes all private sector employers, state and local governments, employment agencies, and labor unions. For smaller employers that have fewer than 15, other federal, state, or local anti-discrimination laws may still apply. So if we're just talking about Title VII, you should make sure that you're adopting and enforcing anti-discrimination policies. You want to make sure that you are clearly defining what constitutes discrimination and harassment. You want to make sure that you're providing training. Offer regular training to employees and managers. Make sure that you have fair hiring practices, ensuring that job postings, interview questions, and promotions are free from bias. Investigate complaints promptly. Establish a confidential process for handling discrimination claims and preventing retaliation. Make sure that if reasonable accommodations are asked for, that you're making them possible as needed. Stay up to date on legal changes. Make sure you're looking at what the court rulings are and EEOC. So what about other federal anti-discrimination laws? Well, there is the Equal Pay Act, or EPA, which requires equal pay for equal work between men and women, and this applies to all employers regardless of size. There's also the Fair Labor Standards Act, the FLSA, and the Occupational Safety and Health Act, or OSHA. Now, I know these are not specifically anti-discrimination, but these regulate wages, overtime pay, and workplace safety, and applies to many small businesses. There are also many states and cities that extend anti-discrimination protections to employers with fewer than 15 employees. So if we take a look at just a couple, California has the Fair Employment and Housing Act. This covers employers with 5 or more employees. It protects against discrimination based on race, sex, gender identity, disability, and more. New York has the New York State Human Rights Law. This covers all employers, regardless of size, and it includes protections for sexual orientation, marital status, and domestic violence victims. In Illinois, there's the Illinois Human Rights Act. This covers employers with 1 or more employees, and it expands protections against discrimination and harassment. In Washington, D.C., they have the D.C. Human Rights Act. This covers all employers, even those with just 1 employee, and provides some of the broadest discrimination protections in the country. Now, I do want to note that with this new current federal executive order, there's a lot of states that are already taking action in response to it. And these actions are on either side of the spectrum. There are 10 states currently that have threatened to sue major financial institutions because of their DEI and environmental programs. Then there are another 13 states that have threatened legal action against Walmart for stopping their DEI programs and training earlier in January. So we want to pay attention to our own states to determine if they are issuing any state-level executive orders in regards to this or any other employment regulation. For private sector employers, each private sector employer needs to decide how they want to proceed with DEI programs, policies, or verbiage that they currently have. You want to make sure that you have DEI programs that comply with existing anti-discrimination laws and regulations, as well as any state law. You also want to make sure that your program does not cause any reverse discrimination or bias in your business practices. The executive order wants to do away with illegal DEI programs. So if you are a private sector employer that wants to keep your DEI program, you need to make sure that it complies with existing anti-discrimination laws and regulations. We also want to make sure that we're aware that more regulations on DEI programs are likely to be released at that 120-day deadline for private sector by the Attorney General. So that's May 21st. That's the deadline that the Attorney General has to figure out what other regulations on DEI programs in the private sector could be and ways to legally address that. We would also like to note that at this time, other EEOC requirements are still in place. Your employment record retention laws are still in place. The posting of your employment law posters are still in place. And recording and submitting of the EEOC Component 1 data is still in place. But as with any changing law, we're going to see modifications. We're going to see adjustments. We're going to hear different legal interpretations along the way as society implements these regulations. We need to keep this in mind and continue to get clarification. So what are our key takeaways from today? The executive order removes DEI items from federal agencies and companies that have a contract with the federal government, not from the private sector. All agencies, businesses, and employers still need to follow the protections under Title VII, the ADA, the ADAA, and other regulations that prohibit employment discrimination in all aspects of business practices and employment. And we need to be alert for upcoming changes and interpretations of this and other regulations. So our list of resources. The EOC has several resources for small businesses, and in fact, they have an entire section of their website that's set aside for Small Business Resource Center. It includes small business requirements, tips for small businesses, resources, a glossary, and fact sheets for small businesses. There is even a small business assistance page that answers questions about laws that the EEOC enforces. They can also work with you to provide needed training. You can utilize all of these resources on their website, eoc.gov/employers/small-business. In the glossary, check out Small Business Liaisons. They are EOC staff who are responsible for helping small businesses understand and comply with federal employment discrimination laws. The Small Business Liaisons, who are located in those 53 EOC field offices that we talked about across the country, they provide information about employment discrimination, they answer questions, and conduct outreach training for small businesses. And most notably, conversations with Small Business Liaisons do not get shared with the EEOC staff who investigate, resolve, and litigate charges of discrimination. You should talk to the EEOC about their no-cost outreach programs and presentations. Make sure that you are compliant and prevent employment discrimination from occurring in the first place by working with an EEOC Small Business Liaison. We hope you enjoyed this week's episode. Send us an email at hrtoolboxpod@gmail.com to suggest topics and let us know what tools you are looking for to improve your workplace. HR Toolbox is a production of Myth Operational Solutions. You can find the HR Toolbox podcast on Spotify or Apple Podcasts and wherever else you get your podcasts. Follow us to stay up to date with the latest HR Toolbox resources and news. See you in the next episode. Don't let anyone put a wrench in your week.